Hi guys, it's Kathy. I hope you're doing well. So yesterday I thought it was Tuesday. Today I think it's Friday. It's Thursday. So I had to refix everything real quick because I thought it was Friday. In my defense, it's very early in the morning. Nothing's working yet. Still not firing. And I haven't had coffee in days. But, all right. What are we doing now? We're doing Georgia. I was going to start with that custody case, but then I used it yesterday. So now we just got Georgia for today. So remember, we watched Georgia during yesterday's live, and the judge, of whom again I don't know his name, maybe we'll figure it out today. I could Google it, I guess. But there was a custody case, and he's like, hurry up, because I'm about to walk out of this courtroom. I'm about to get up and walk out of this courtroom and just leave you all here. I have places to go. Hurry up. Well, this is where he had to go. So this was what he did after that. And then I'm going to show you what he did after that, too, I think. I think they were all from the same day. Bill's here. I don't know how to use the Google. I think the Google is a passing fad and it'll just go away. So, actually, remember when CJ used to Google all of our words? Every word we said, she's like, whoa, Googling that. Now she's American. She's so American, she tells us what our words mean now. I wonder if she could tell me what my last text in mod chat meant. My cat got my keyboard and I had mod chat open because they were talking after the live. And I sent them a weird message. It's fine. They'll figure it out. If you don't figure it out, you're in trouble. You mods have to know what I mean. All right, hold on. Let's go. Stop talking. Here we go. Georgia.
All right, next up is our probation revocation calendar, case number 2025R0144-MJ, State versus Charles Anthony Anderson. That's you, sir?
Yes, sir.
I'll note for the record that Mr. Anderson is standing at the podium with Mr. McLaughlin. This case appears on my probation revocation calendar. Mr. McLaughlin, what's your announcement?
Your Honor, this will be an admission to the count contained in the petition, and what we expect is an agreed upon disposition, at least according to what was represented to me in the notes, that he would be resentenced to serve 4 years and the balance of his probation be terminated, or that he be sanctioned by being sent to the Department of Corrections for 4 years and the balance of any sentence be terminated.
So this is an adjudication. Is this a petition for adjudication or just revoke?
So, Your Honor.
Just going to revoke?
It is, Your Honor, and I'm sorry, I'm going from notes and I have not even read.
All right, so 4 to serve, terminate any remaining balance.
Correct.
Anything to add to that, Mr. Parkinson?
No, Your Honor, that's the state's agreement.
All right, Mr. Anderson, it appears that you and Mr. McLaughlin and Mr. Parkinson have been discussing your case and have reached this joint recommendation to the court. I'm going to have a lot of questions for you in just a minute, but as I understand the situation, you are expected this afternoon to admit the factual allegations in the petition, and that upon those admissions, the court will revoke 4 to serve with DOC and terminate any remaining balance. Is that what you understand is supposed to happen, Mr. Anderson?
Yes, sir.
Before I can get to the disposition phase, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this, although it seems pretty straightforward, but just as important that you understand all of the rights that you'll be giving up if you complete these admissions today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. McLaughlin, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far, Mr. Anderson? As best you're able, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
You put your hand down. Mr. Anderson, do you understand this is a probation revocation proceeding?
Yes, sir.
And do you understand the sentence recommendation of 4 to serve the DOC, terminate any remaining balance? Do you understand that?
Yes, sir.
Before the court can decide or determine whether or not to accept this recommendation and these admissions, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. I have some preliminary questions to ask you first, however. Are you now under the influence of any intoxicants like alcohol, drugs, narcotics, or prescription medications? Is your mind clear today?
Yes, sir.
Do you know where you are and what you are doing?
Yes, sir.
Do you understand the court does not have to accept the sentence recommendation? Other than the sentence recommendation, has anyone promised you anything to get you to make these admissions today? Has anyone threatened you or frightened you to force you to make these admissions today? According to the petition, your original sentence was dated March 28th, 2016, at which time you received, if I'm reading this correctly, well, let's see, 10 to serve, apparently a split sentence with a total of 20 years, due 10, balance on probation. And if I'm reading this correctly, then therefore your original sentence should be set to expire on March 27th, 2036. Is that right, Mr. Parkinson?
That's correct, Your Honor. 2036.
All right. You agree with that, Mr. Anderson?
Yes, sir.
Court does further advise you that instead of your probation being revoked, as you're doing now, that you have the right to demand a formal hearing before this court in which the state of Georgia must prove that you have violated the terms and conditions of this probation by what is called a preponderance of the evidence, which means more likely than not. Do you understand that? If you demand such a formal probation revocation hearing, Georgia law guarantees you the right to confront and question all witnesses who accuse you, the right to subpoena your own witnesses and evidence in your behalf, and to offer these witnesses and evidence at the hearing, the right to the continued assistance of your lawyer at all stages of the hearing, the right to testify yourself if you wanted to, and the right not to incriminate yourself. You may testify or not, and you personally would decide if you testified or remain silent or not. If you do not testify, which is your right under Georgia law, then the court cannot use that decision against you in any way. Mr. Anderson, do you understand that by making these admissions, you are agreeing to give up this formal hearing and all of these rights? Do you understand that? Now, you're represented here today by Mr. McLaughlin. Is that correct?
Yes, sir.
Have you had enough time to talk to Mr. McLaughlin about this case? Do you need any more time to talk to Mr. McLaughlin about anything involving this case?
No, sir, I do have a question.
For me or for him? All right, go ahead.
If you do accept the time that I'm giving, will it count as when I first got locked up, or?
Well, no, that's typically handled by an affidavit, but I don't know that there was any discussions about picking a day. But typically the jail makes that decision unless there's an agreement.
He will, John. You'll get that.
All right. You understand that?
Yeah.
Okay, I don't make that decision.
Okay.
The jail makes that decision. You understand that?
Gotcha.
Okay, great. Any other questions, Mr. Anderson?
No, that's it.
All right. Do you have any objections about how your case has been handled, Mr. Anderson?
Sir.
Anything else you'd like to say? You don't have to, but you can if you want to.
No, sir.
All right. Anything else from the state?
Nothing further from the state, Your Honor.
All right, Mr. Anderson, do you freely and voluntarily admit the facts about how you violated the terms and
Thank
conditions
you.
of your probation
Thank you,
as set
JK.
out in
Thank you. Thank you.
counts? Well, only one count. Apparently, allegedly failed to successfully complete the McCaver Probation Detention Center sentence. Do you make that admission here today, Mr. Anderson?
Yes, sir.
All right. Anything else from the defense, Mr. McLaughlin?
No, Your Honor.
All right, Mr. Anderson, the court finds that you have made a knowing, intelligent, and voluntary waiver to give up your right to a formal probation revocation hearing, and the court does accept your admission as a sufficient factual basis, and the court will accept the recommendation to revoke 4 years to serve with DOC, and then upon your release, terminate any remaining balance. You got any questions about that, Mr. Anderson? All right, very good. That will conclude your case, Mr. Anderson.
Is that
Good
him?
luck to you.
All right, look. See him? Can you see both? Darn it. I knew that was going to happen. Does that look like him? because we see him all the time and we don't know his name. Now we do. He skips the C. So it's Mike. Mike Johnson. So we have Eric Johnson, and now we have Mike Johnson.
If you don't know.
So we will call them Judge Eric and Judge Mike. What do you think? It's C. Yeah, we have CJ. That's enough. That's enough. Watch. Now that I Googled it, someone's going to say his freaking name in this docket.
There we go.
Got another revocation.
All right, Mr. Deal, who you want to call up next?
Your Honor, may I make an announcement, please?
Sure.
On the plea calendar, position 9, Mr. Gerard Hughes.
Clevis.
That's him right there on the front row. Yes, sir.
Yes, Your Honor. The District Attorney's Office has made an offer in that matter of 10 years probation on count 1. Mr. Hughes
Clinton.
wishes to discuss that with his family before he proceeds, and the District Attorney has generously agreed to leave that offer open. So if we could continue that from today's calendar, please.
All right. Anything?
Here's my guess. Clarence. Here's my guess. His name is Mike Johnson. So his first name has to be Christopher, because Mike Johnson is such a generic name. So I'm guessing his first name is Christopher, but his daddy and his daddy was already Christopher. Christopher Paul, Christopher Peter. So he's not a junior. So the way they keep their Christophers apart is they call them by their middle name, which is Mickey. So that's what I said. I said Cletus. This is Mickey. This is no longer Judge Mike. This is Mickey. Mick for short.
To add, Mr. Parkinson?
No, Your Honor, no objection to continuing this case.
All right, Mr. Hughes, I don't know when your next court date will be, but did you receive the notice in the mail for today? All right, very good. You'll get another one. I just don't know when it'll be, but you're free to go for today. Thank you, sir. And unless I've missed something, that leaves us with Mr. Basby. What's the status of that one?
Mr. Basby is a show cause and the state is ready.
All right. Who's going to handle that one, Mr. Deal? All right. Wise decision, wise decision. Yeah, hold on to it just a second. All right, thank you. Did you file a petition, or are there multiple cases on Basby? How does that work? Oh, you got them. Okay. Okay.
I think this is the one where the inmate forces the lawyer to ask the judge for something that the lawyer is not comfortable with asking.
Okay.
Where's Mr. Basby?
He's coming now.
He's coming. Okay. He's in the back though.
Yes.
Okay. Or 0185 021 2024 or 0230 25R 0047 and 0093. All styled State versus Jimmy Banks Basby. That's you, sir?
Yes, sir.
I'll notice Well, note for the record that Mr. Basby is standing at the podium with his attorney, Mr. McLaughlin. And Mr. McLaughlin, all I have in front of me is the calendar that says show cause. So I presume there was some sort of suspended sentence from the original cases. And so what's the announcement from the defense, Mr.
Senator, it's
McLaughlin?
my understanding, just to make sure that as Judge Koppel says, there's a limit to the understanding, but not a limit to the misunderstanding two people can have. Mr. Basby was sent to complete, as a special condition of his probation, a stay at the rescue mission in Atlanta.
No, in Macon.
Sorry, Macon. And the state contends pretty obvious he's not at the rescue mission in Macon. He's standing beside me. So he did not complete that. The state's contentions are that he was discharged from there and kicked out. Mr. Basby claims that is not what happened. He was told he had to have a mental health evaluation and left on his own accord to go have that done. I think there's also an allegation that he refused a drug screen. Mr. Basby's response to that was his probation officer in Macon never asked him for a drug screen, and that's where he was supposed to be reporting. So that's why we're here, Your Honor.
All right. So as I understand the situation, then the Officer Long, what you've presented to the court is what Mr. McLaughlin just stated is sufficient cause for the court to lift the suspended PDC part or still the sentence. Is that correct, Mr. Parkinson?
That's correct, Your Honor. That's what the state is requesting, for that PDC now to be unsuspended.
All right. Anything to add, Mr. McLaughlin?
Your Honor, Mr. Basby don't want to go. He wants to go home, or an alternative wants to go to a treatment center. And so I told him I would ask that. As the court knows, I don't get to pick the car. I got to race what I brung to the track, and I brought Mr. Basby today. And he's adamant that if the court will give him a chance to get in.
I know, we're going to hear that again. He does not want to say this to the judge. He just doesn't. I have to hear it again. I have to hear what he says.
As the court knows, I don't get to pick the car. I got to race what I brung to the track, and I brought Mr. Basby today. And he's adamant that if the court will give him a chance to get into a Thor-approved treatment center, he will do that.
Well, you indicated, Judge Koffel, these are all HK cases, so I presume he sentenced Mr. Basby pursuant to some negotiated plea with this.
On the waiver.
Yeah, to go to the.
Yeah, go to the rescue mission. Ain't signed no way we go no PDC. No, I definitely go. I definitely signed no way we go no PDC. Nah.
Well,
I didn't sign no way.
Mr. Basby, I mean, I'm not trying to hurt your feelings, but this deal was made back in June 18th, 2025. And Judge Koffel signed off on it on June 20th,
So, like, who signs up to go to the PDC? I didn't sign that.
25, and I am not about to scramble that deck.
Sir,
My only issue today is to find where there is sufficient cause to lift the suspension, and I'm going to find that there is. Now, I don't know what the weight is. I get the email every week from Chief, but I didn't look at it this week.
2 to 3 weeks.
Hey, y'all.
3 weeks.
Good to speak, y'all.
Now, hold on.
Oh, go ahead.
I'm going to follow through on the deal that was made back in June. Now, that you got 3 weeks, apparently.
Sir.
You got a wait of 3 weeks. So if you and Mr. McLaughlin want to come up with something else.
Yeah, I'll wait, sir. Cause I know PDC can't off me now, so I did not get kicked out of the where I was at rescue mission. So they told me I had to take a mental health evaluation before I come back. My nephew that got me in that, he's a school teacher at the north side of Ronald Robin, and he had to go back, you know what I'm saying, sir, and build, you know what I'm saying, do his job. So I couldn't get contact and going to mental health evaluation, sir. That's all I can do. I take a mental evaluation, I can go right back where I was at, sir.
Well, you got to take that up with Judge Koffel. I'm lifting the suspension.
Yeah.
And that's the order.
Yeah, I'll wait 3
Good
weeks,
luck
sir.
to you,
Yeah, I
Mr.
will
Bass.
definitely wait 3 weeks.
All right. Andrew, here's your record check back. I don't want Commissioner Nail coming to my house to get that thing back.
Okay, that is, so he ran from this same courtroom, I think. He was already in this courtroom. He told those lawyer ladies, hurry up. And I think that because, look, Cindy is still in the same clothes, in the same seat. All right. And he's like, I'm going to go. But he didn't really go. He's down. He's in the same thing. And then he did go. Okay. He just shut down the live stream. Then he did go. And this is where he went.
The court date in the mail. I don't know when that.
So I can't remember the name of this courtroom or the county that this is. I think it starts with an N, but it's not coming to me because it's so rare that we ever see this courtroom. We see it. We've seen it with Caulfield and we've seen it with Reeves and Judge Mikey. But this is where he went after that.
That'll be, did you receive your notice for today?
Yes, sir.
All right, very good. You're excused for today. Thank you, sir. Number 6 is Donovan. Oh, that's a Hick. That's another DOC. That one will be rescheduled.
I think this guy was in the other courtroom, though, wasn't he?
And 7,
Maybe I'm
Andrew
wrong.
Walker White.
I don't think
Your
so.
Honor, that would be a negotiated plea. I'm borrowing the clerk's file right now with the plea sheets.
I don't know who Judge Hick is. I know that Judge Caulfield's first name starts with an H. And so when he signs orders, he signs it HC. No, I really think it's an N. It starts with an N. Oh, Luna's mad. So Judge Hick, they say Judge Hick a lot. I've never met a Judge Hick, nor have I seen one on the websites. So I think that maybe Judge Hick might be Judge Caulfield, but I don't know.
All right.
He got behind that accident, came in a little late. We call it case after I had a chance to meet with him and go.
Certainly.
All the time.
All right. Is there anybody's name that I did not call who expected their name to be called for today? All right. Very good. Then I'll start back with take the pleas first, and then we will come back. So the first one I see is Keisha Stevenson. You ready to do that one?
Yes, Your Honor.
All right. Come on up, Ms. Stevenson. Make sure that thing is working. That's the wireless. Of course. Very good. All right, give me just a minute. All right, so it's going to be counts 1, 5, and 8. All right, 1, 5, 8. Count 1 is felony possession. One to 10. Count 5. 1 to 5. Count 8. 1 to 5.
Yes, ma'am. 10, 5, and 5. 10, 5, and 5.
Count 5 is 4.
All right, the court calls position number 4 on our trial calendar, case number 24CR041-J, State of Georgia versus Keisha Stevenson. That's you, ma'am.
Yes, sir.
I'll note for the record that Ms. Stevenson is standing at the podium with her attorney, Ms. Cameron. Ms. Cameron, I've been handed up a plea sheet here. Will you run through this for me, please?
Your Honor, I need to make one change to that. Your Honor, she will be entering a guilty plea requesting this under the First Offenders Act to counts 1, 5, and 8. With regards to count 1, we anticipate a recommendation of 10 years probation with a $1,000 fine. Count 5 will have 4 years probation.
4? You said 4?
4 years probation, a $500 fine. And then count 8 will have 5 years probation, a $500 fine. Each of those will run concurrent, so a total of 10 years probation. She will also be under drug and alcohol and Fourth Amendment waiver while on probation. She will also be banished from any DOC properties and surrender her post-certification. I have made a note and made a change as to the sentencing range as to count 5, and I have initialed and I'm asking Ms. Stevenson to initial it as well.
All right, Ms. Stanley, you have anything to add to the recommendation?
No, that was correct.
All right, Ms. Stevenson, it appears that you and Ms. Cameron and the DA's office have been discussing your case and have reached this joint recommendation, or a negotiated plea, as we call it. I'm going to have a lot of questions for you in just a moment, but so far, has everyone said what you expected them to say?
Yes.
Before I can get to the disposition phase of your case, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this plea, but just as important, that you understand all of the rights that you'll be giving up if you complete this First Offender Act plea today. If at any point during this process you don't understand my questions, or you need some more time to talk to Ms. Cameron, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far?
Yes, sir.
Right, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
Put your hand down. Ms. Stevenson, do you understand that you were pleading guilty under the First Offender Act to counts 1, 5, and 8?
Yes, sir.
And do you understand the sentence recommendation of essentially 10 years probation on count 1, 4 on count 5, and 5 on count 8, all to be concurrent with a fine and all these other conditions? Do you understand that?
Yes, sir.
Is that what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
Before the court can decide or determine whether or not to
Thank
accept
you,
these
Kelly.
pleas
Thank
and
you,
this
thank you, thank
recommendation,
you.
the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. Do you understand everything so far?
Yes, sir.
All right, according to the plea agreement, we will focus on counts 1, 5, and 8. They are all felonies. Count 1 is possession of marijuana with intent to distribute. It has a maximum. Now, is this going to be a different, or just felony possession, or is it with intent?
With intent.
And it's still 1 to 10?
Yes,
Okay,
sir.
just making sure that you were charged in this indictment in count 1 with felony possession of marijuana with intent to distribute. That has a maximum penalty of up to 10 years to serve in prison, with the sentencing range of 1 to 10 years to serve in prison. Count 5 is crossing the guard lines with a weapon that is also, or it's also a felony. It has a maximum sentence of up to 4 years to serve in prison, with a range of 1 to 4. And count 8 is violation of oath of office by public officer, also a felony with a maximum sentence of up to 5 years to serve in prison, with a range of 1 to 5 years to serve in prison. Now, those are important for lots of reasons, but one of which is the sheet indicates that you wish to offer this as a First Offender Act plea. The court does advise you that if a first offender probationer violates the terms of this probation and the court later enters an adjudication of guilty, the court may then impose any sentence permitted by law for the 3 offenses you're about to plead guilty to. At a probation revocation and adjudication of guilty hearing, a first offender probationer may then be resentenced to a sentence greater than what you get here today, up to the maximum amount allowed allowed by law, which could be all of three of those added together. Do you understand that, Ms. Stevenson?
Yes, sir.
And you still wish to proceed with a First Offender Act plea, is that correct?
Yes, sir.
Very well. The court does further advise you that you cannot be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence that would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of the jury beyond a reasonable doubt. You would have the right to be represented by your lawyer at all stages of the trial. If you could not afford to hire a lawyer, then at your request, the court would appoint a lawyer to represent you without cost to you for the trial, where you would have the right to confront, question, and cross-examine all witnesses and persons who accuse you. You would have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court would issue subpoenas directed to your witnesses to compel them to come to court. You would have the right to testify in your own behalf, but you cannot be compelled to testify nor to incriminate yourself, because you have the right to be present, including the right to be present and remain silent. You would also have the right to ask the court to suppress
Thank you,
any
Monica.
legally
Thank
obtained
you, thank
evidence.
you.
And if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court. And that would include the right to be represented on that appeal by your private or retained or court-appointed attorney, as the case might be. Ms. Stevenson, do you understand that if you plead guilty today pursuant to this plea agreement, you will be giving up or waiving all of these rights that I've just explained to you for this case? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of your probation. Do you agree and understand that as a special condition of probation will be that you shall submit to a search of your person and property at any time of the day or night, with or without your consent or a search warrant, whenever requested to do so by a probation officer or a law enforcement officer? Excuse me. And if anything is taken, it may be used against you as evidence in a further court proceeding. Do you understand that?
Yes, sir.
And you're represented here today by Ms. Cameron, is that correct?
Yes,
Have
sir.
you had enough time to talk to her about your case?
Yes, sir.
Do you need any more time to talk to Ms. Cameron about this case?
No, sir.
Do you have any objections about how your case has been handled up to this point?
No, sir.
Is this your free and voluntary plea?
Yes, sir.
Has anyone threatened you or frightened you to force you to plead guilty?
No, sir.
Other than this plea recommendation, has anyone promised you anything to get you to plead guilty?
No, sir.
Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
No, sir.
Is your mind clear today?
Yes, sir.
Do you know where you are and what you are doing?
Yes, sir.
Can you read and write?
Yes, sir.
Do you have any questions about anything that has happened up to this point?
No, sir.
If you are not a United States citizen, a guilty plea will affect your immigration status. Ms. Stevenson, are you pleading guilty under the First Offender Act to count 1, ladies off the indictment, possession of marijuana with intent to distribute, count 5, crossing the guard line with the weapon, and count 8, violation of oath of office by a public officer, because you are in fact guilty?
Yes, sir.
All right, Ms. Cameron, say that her plea gets entered.
Two, 34. Through. Nine through 10. Okay, just something right there. You're under the guilty plea to counts 1, 5, and 8 under that.
Facts of the case, please.
On or about the date in the indictment, Ms. Stevenson was an employee of Wheeler Correctional Facility. She did report to work that day, and she had a gun in her vehicle, crossed the guard lines with that, which she was not allowed to do. She also had an amount of marijuana such that was indicative of distribution in her possession.
Anything from the defense?
Your Honor, we would just request that the court accept the recommendation as previously stated in the case.
All right, Ms. Stevenson, do you have any questions about anything that's happened up to this point?
No, sir.
Is there anything that you would like to say? You don't have to, but you can if you want to.
No, sir.
Very well, the court finds that the plea has been freely and voluntarily entered. That there is a factual
500.
basis
Oh
for
my
the
gosh,
plea, and the
thank
court
you.
will accept the plea and the
Thank you, guys.
recommendations,
Thank you.
as was stated,
To put that in perspective, so they pay, when you're on Twitch, you pay and you buy all these bits that you can cheer with. Okay? Not exactly sure how much a bit costs. I get a penny from every bit. So 500. He just cheered 500 bits. For me, that's $5, but for him, he probably paid, I don't know. I don't know if it's double. I don't know if it's triple. I don't know what it is that he paid for that. But thank you, Fozzie. Thank you. Thank you.
counts 1, 5, and 8, all under the First Offender Act. Count 1, 10 years probation, $1,000 fine, plus the add-ons that go with it. Count 5 will be 4 years, concurrent, $500 fine, plus the add-ons. And count 8, 5 years concurrent, $500 plus the add-ons that go with it. All of this will be served under drug and alcohol conditions, Fourth Amendment waiver conditions. You have a period of 4 years to file a habeas corpus petition from the date these sentences become final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm?
I do.
And where was that permit issued?
Wheeler.
Wheeler County. All right, very good. It'll be banned from DOC properties while under this sentence and surrender post certification. You'll need to meet with Chief Carmen here. He'll process you through, Ms. Stevenson, but that will conclude this matter. Good luck to you.
All right. Thanks, sir.
Thank you. Let's see, you got one of those over here. There we go.
He muted it. Just relax. Just breathe. He muted it. He does that sometimes. Now he's going to turn it back on. He's going to have her. He's going to have her walk around and tap on the microphones. Tap that microphone. Tap it. No. Tap it again. Keep tapping it. Hold on. Let me get someone else. So funny when he does it. Just move your monitor. Y'all are drunk. It's straight to me. Mickey, unmute it. Here he goes.
Next up is case number 25CR007-J, State versus John Edward Williams. That's you, sir?
Yes, sir.
Your Honor, we also have another case. Does Your Honor have both of them? I'm
Okay.
sorry.
That's all right. That's all right.
Yes,
Let her,
the other one is 25R008.
007 and 008. Double 007 and 008.
Maybe it's a submarine and it's supposed to sink. You ever think about that? We're not Kit Kat. You're drunk. You're drunk. Georgia has the best judges. Since you all are here, a lot of you are here. A lot of you. I am right now recording a trial with Judge Eric. And you know how remember when Judge Fleischer did that trial and we were so excited, and then it was sort of like anticlimactic because Judge Fleischer didn't really talk that much during the trial. It was all the stupid lawyers, and we could barely hear them, and it was the witnesses, and we could barely hear them. And every once in a while, they would say, "Can we approach?" And then Judge Fleischer would say something that we could hear, and then sometimes couldn't hear. Judge Eric has a lot of opinions, and he freely gives them throughout the trial. So really, we're going to hear Judge Eric a lot during this trial once it's still going on. So I can't show it yet. But and I have to do a lot of editing. I got a 9-year-old on the witness stand that I got to blur, and it's hard to blur because she's like in her chair, she's like whoo, and she's like jumping around a lot. And I don't want to blur just that whole big block because she's moving around so much. So I got to make sure that and I'm not an editor. I'm not an editor. I'm just not. Thanks, Josh. Just if you guys, I'm so thankful that you guys, got asked friends and family to get me to 9,000 subs. I am. Please know that I am, and I'm not. I don't mean this as complaining in the slightest bit. But if you do suggest my channel to someone, if you suggest it to someone who likes trials and court cases and true crimes, that would be very helpful because YouTube looks at the history of people who sub, and if they're not true crime people, like those subs, if they try to push my video or my live stream out to those people who just subbed, and they're like, I'm not clicking that. No way, I'm not clicking that. My numbers go down. So if you do suggest it to someone, just you know, see if they like true crime or anything. Um, it's okay. Everything's fine, and I'm so thankful, and I'm so happy to be at 9,000 subs. I just, I just can't believe that. I can't believe we're only 1,000 subs away from 10,000 subs. Once you hit 10,000 subs, you channels gets like this better special treatment. So yeah, you know enough. You think this courtroom is slanted. You're drunk. You know true crime people. Yeah, they do spy on you. That's how they give you videos you like though, so it's a good thing, you know? Could you imagine if they didn't spy on you and they just threw a random thing? You got League of Legend videos all day? No, I don't get a plaque at 10,000 subs. Plaque psoriasis, maybe.
Okay. All right, here is this is 008. Okay. All right, there we go. 07.
Oh, Tona, you don't have to answer their surveys. They know you.
08
They know what you watch.
-K. All right, well, I'll need a.
Yeah, they don't just know what you watch. When you guys scroll through things, they track how long your eyes are on each. So even if you don't click it, if your eyes are on a thumbnail or whatever for a certain amount of time, they track that. And they track how you look at a web page, what you look at they track it all.
Reassignment order for that one. All right. Let me take a look. Oh, I'm sorry, Ashley, Mr. McLaughlin. I threw it right down at you. Sorry. Give me just a minute here. Let me write all this down before we get started.
Same here. When I'm just watching something, it's always YouTube.
How old are you? 39.
They give me the worst stuff when I'm sleeping.
There's time.
I don't even get it. I don't even get how I get some of it.
It's always gals. It's always gals that end up indirectly getting your ass in trouble. You don't say.
It's always gals. It's always gals that end up and get your ass in trouble. That's what the lawyer just said to him.
Yeah. How old is Lisa? She can't be 43. Really? Hope she takes a good picture. All right, I have 07 and 08 now, police sheets on both of those. So Mr. McLaughlin, just run through this real quick for me.
Yes, Your Honor. With regard to the cases signed to Your Honor, that is 25R007J, that also the one on the calendar today. Mr. Edwards is going to enter a guilty plea to the count of possession of firearm by convicted felon. That is a felony that carries a sentencing range of 1 to 10 years and a fine of up to $100,000. If the court accepts recommendation, he'd be sentenced as to that particular case to 7 years. He can serve the same on probation. That would be subject to drug and alcohol conditions and a Fourth Amendment waiver. He would be ordered to pay a fine in the amount of $500. And I believe that covers that case.
All right. And 008 is?
That is a possession of methamphetamine that carries a sentencing range of 1 to 3 years and also a fine of up to $100,000. If the court accepts that, he'd be sentenced to serve 3 years. That can be served on probation, subject to drug and alcohol conditions and a Fourth Amendment waiver. Also a fine in the amount of $500.
Anything to add to that, Ms. Stanley?
No, that was correct.
One. I think count 2 is drug-related object.
Oh, there is. Okay.
That, the other count in that one's a misdemeanor drug-related object, unless I'm bad, wrong.
The count 2 would be non-pros, is that right?
Yes.
All right. Anything else to add to it, Ms. Stanley?
No.
All right, Mr. Williams, it appears that you and Mr. McLaughlin and the DA's office have been discussing your 2 cases and have reached this joint recommendation, or a negotiated plea, as we call it. So far, has everyone said what you expected them to say?
Yes, sir.
Before I can get to the disposition phase of both of these cases, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of these plea agreements, but just as important, that you understand all of the rights that you'll be giving up if you complete these pleas today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. McLaughlin, just let me know, and I'll give you all the time that you need within reason. You understand everything so far?
Yes, sir.
Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
Put your hand down. Mr. Williams, do you understand that you were pleading guilty in 007 and 008? Do you understand that?
Yes, sir.
And do you understand the sentence recommendations of 7 years probation on one, 3 years on the other with a fine and all these other conditions? Do you understand that?
I do.
Is that what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
Before the court can decide or determine whether or not to accept these pleas and these recommendations, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. As has already been stated in 007, that charge is possession of firearm by a convicted felon. That is a felony and has a maximum sentence of up to 10 years to serve in prison with a range of 1 to 10. And 008 is possession of meth. That is also a felony with a maximum sentence of 3, with 1 to 3 being the range. The court does further advise you that you cannot be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea on both of these cases and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence that would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of the jury beyond a reasonable doubt.
All right, he's talking, but look, ladies. Thank you, CJ. Look at how he's standing. Could you imagine standing like that for a long period of time, like that, in that position, the way he is? Like, I would fall backward. I would fall down. I feel like I would fall backwards if I stood like that for a long period of time. And I know it has to be, because anatomy, because of the way our hips, because of the way our hips are like in a different shape and space than in a man's hips. But if I stood like that, I would fall. That would make me fall down. But that's how men comfortably just stand. And they're not going to fall over. Well, some of them do, but most of the time they don't fall over. Now, this lawyer, I would not fall there. If I was just on one leg, I would be perfectly fine. That I would not fall on. But standing like this, it just, would be, I would, I would be on the floor so fast because men don't have hips.
You would have the right to be represented by your lawyer at all stages of the trial. And if you could not afford to hire a lawyer, then the court would appoint a lawyer to represent you without cost, where you would have the right to confront, question, and cross-examine all witnesses and persons who accuse you. You would have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court issue subpoenas directed to your witnesses to compel them to come to court. You would have the right to testify in your own behalf, but you cannot be compelled to testify nor to incriminate yourself because you have the right to be present, including the right to be present and remain silent. You would also have the right to ask the court to suppress any illegally obtained evidence, and if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court. And that would include the right to be represented on that appeal by either your court-appointed attorney or private retained attorney, as the case might be.
See, now she's standing like him, but she's holding on. She's got a firm grasp on that desk. If her hands were not on that desk holding herself, her legs would just not be in that position. They just wouldn't.
Mr. Williams, do you understand that if you plead guilty today pursuant to this plea agreement in both cases, you will be giving up or waiving all of these rights that I've just explained to you for these two cases? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of your probation. Do you agree and understand that as a special condition of probation will be that you shall submit to a search of your person and property at any time of the day or night, with or without your consent, or a search warrant whenever requested to do so by a probation officer or a law enforcement officer. And if anything is taken, it may be used against you as evidence in a further court proceeding. Do you understand that?
Yes, sir.
And you're represented here today by Mr. McLaughlin, is that correct?
Right.
Have you had enough time to talk to him about these two cases?
I have.
Do you need any more time to talk to Mr. McLaughlin about anything involving these two cases?
No, sir.
Do you have any objections about how these cases have been handled?
No, sir.
Is this your free and voluntary plea?
Yes, sir.
Has anyone threatened you or frightened you to force you to plead guilty?
No, sir.
Other than these two plea recommendations, has anyone promised you anything to get you to plead guilty?
No, sir.
Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
No, sir.
Is your mind clear today?
Yes, sir.
Do you know where you are and what you are doing?
I do.
Can you read and write?
I can.
Do you have any questions about anything that's happened up to this point?
No, sir.
Is there anything that you would like to say? You don't have to, but you can if you want to.
No, sir.
All right, Mr. Williams, are you pleading guilty in 25R007 to receipt, possession, or of firearm by convicted felon because you are in fact guilty?
Yes, sir.
And in 008, are you pleading guilty to count one, possession of methamphetamine because you are in fact guilty?
Yes, sir.
All right, Mr. McLaughlin, see that his pleas get entered.
I got a field trip. Hurry up, Judge. Hurry up. All right, I think he's done. Let's go on a field trip. I think I have to add this playlist right here to my channel description. Okay, here's what's going on. I live in Pennsylvania, right? I don't live awfully far from Philadelphia. I'm very close to Philly. Listen, if I had to put money down, I would that this lawyer's from Philly. But his commercials I hear here. So I think he has an office close to me or right in the city that I live in. This lawyer plays these videos. Plays these commercials on the radio. I hear every day. And they are the greatest lawyer ads you are ever going to hear. I just looked it up real quick while I was talking to you guys, so I don't know. I can't pick out my favorites from this list. So, are you ready? I'm going to go with this one because it's actually named Why Me, and then I'll go with another one. Oops.
Outcome of each person's recovery. Attorney advertising. Prior results do not guarantee similar outcome of each person's recovery depends on the facts and laws of each client's case. Why me? Why me? You could have picked anybody else in the world for this to happen to, but you chose me. I was a good person. Never did nothing to nobody. And I'm here. This is crazy. I was just going to the store. That was it. Car ran a red light.
Car ran a red light.
I died 2 times.
I died 2 times.
To the hospital. And I had a stroke. And I didn't diagnose it in time. And I messed up for life. But I'm about to get $5. I called Top Dog.
Top Dog.
Medical malpractice. In a car accident. Any accident. Top dollar. TopDogLaw.com.
All right, hold on.
Mirror are closer than they appear, and so is a monumental entertainment destination.
Hold on.
Attorney advertised. Paid active. Prior results do not guarantee a similar outcome. Each person's recovery depends on the facts and laws of each client's case. What would you do if you got into an accident today? Off your feet for the next 2 years. Can't even take care of yourself. Somebody got to do everything for you. How your bills going to get paid? How you going to take care of your kids? You can't go to work. What would you do? Gotta call somebody. And it can't just be anybody. You need an animal on this.
These are good, but these aren't the right ones. Hold on.
Free. Attorney advertising. Prior results do not guarantee a similar outcome. Each person's recovery depends on the facts and laws of each client's case. Today you received a call from Top Dog. Told you your settlement check was ready. Thinking to yourself, damn, that was quick. Seemed like it just happened. You asked Top Dog, how much is the check?
97.
You in an accident right now. You can't even get out your car. Attorney advertising. Prior results do not guarantee a similar outcome. Each person's recovery depends on the facts and laws of each client's case. You pull up to a red light. It's you and your wife. You got matching Hellcats. You say you want to race? She say yes. You say when the light turn green, we go. First person to the next red light wins. Light turns green. Tires start spinning. Y'all go. As y'all driving down, car pulls out of a parking spot. Boom! Wife hits the car. Jump out of your car. Check on your wife. Wife is hurt. Check on the person she hit. And they ain't moving. All you can think about. Top Dog. They're calling Top Dog. This ain't good. They're calling Top Dog. Top Dog gonna want all the money. He's coming for top dollar. You knew you shouldn't have raced. You knew it, but you did it, and now you have to pay. Follow him on Instagram at Top Dog Law. It's
Those weren't it, but that's okay. Like the last one, he's like, you driving to work, you following a truck, the truck loses its tire, the tire goes through your windshield. You crawl out of the car, you get in the ambulance. The ambulance gets into a car accident. You fall out on the road. The police scoop you up. They're taking you to jail. Why me? Why are they taking you to jail? Call Top Dog. It was so funny. It just keeps getting worse. These are all a year old. He's gotten way better in the last year. Oh man, every morning when I drive my daughter to work, I hear his commercials and they are so good. I know if I ever need a lawyer, I'm freaking calling Top Dog. I don't care. I don't care if he doesn't do criminal. I don't know what he does. I think he does do criminal, but he definitely does medical. But there's Tina, they're so good. I wish I could get the new ones. The new ones are really good. Anyway, let me just get to the next guy.
They also searched the house. Went to
Facts of the cases, please.
on or about the date in the indictment in 25 CR 007, the Oconee Drug Task Force went to Mr. Williams's residence with an arrest warrant. They also searched the house and they located it was a pistol. Mr. Williams is a convicted felon and was not able to have that pistol. That's the basis for count 1. And then in 25 R008, on or about the date in that indictment, pursuant to a search of Mr. Williams's residence, agents of the Oconee Drug Task Force did locate an amount of methamphetamine.
Anything from the defense, Mr. McLaughlin?
Your Honor, I'll just state for the record, Mr. Williams has always been a hardworking guy. He's a truck driver. He's never been without a job, taking care of himself, taking care of business, but methamphetamine has been his Achilles heel, as it has been for so many others. He has since severed ties with all those folks that he was associating with, and after some time in jail as a result of these charges, is doing much better. He don't even look like the same person. He's back up this fighting weight and looks good, Your Honor.
Okay, I'll make sure that's in there somewhere. All right. Well, that's all sounds good, Mr. Williams. The old ways and the old bad old days and the old ways are still out there lurking. The hard part is staying away from it.
Right.
Age will take care of a lot of those things, but I'm glad to hear all those good reports. Keep it up. Get this behind you and move on. Anything else you'd like to say, Mr. Williams?
No, sir.
You have any questions whatsoever?
No, sir.
Very well. The court finds that the plea has been freely and voluntarily entered in both cases, and the court finds there is a factual basis for the plea in both cases and will accept the recommendations. As was stated in 007, it'd be 7 years to serve on probation, $500 fine plus the add-ons. And 008 will be 3 years on probation, concurrent, $500 plus the add-ons. And concurrent, if I didn't say it already. Both of these cases will be served under drug and alcohol conditions, Fourth Amendment waiver conditions. You have a period of 4 years to file a habeas corpus petition from the date these sentences become final, and 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. Williams?
No, sir.
Very well. Probation will meet with you, Mr. Williams, process you through. Good luck to you, sir.
Thank you.
All right.
Please don't come back. Please don't.
Ow. All right, I think I got it. Mr. White, it appears you are Andrew Walker White, is that correct?
Yes, sir.
I'll note for the record that Mr. White is standing at the podium with his attorney, Mr. McLaughlin, and Mr. White was standing at the podium when this settlement agreement or this negotiated plea was announced to the court. I'm going to have a lot of questions for you in just a moment, Mr. White, but so far, has everyone said what you expected them to say?
Yes, sir.
And did Mr. McLaughlin correctly repeat the terms of the negotiated plea that's been submitted to the court?
Yes, sir.
Before the court can decide or determine whether or not to accept all this and get to the disposition, the court must first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this plea, but just as important, that you understand all of the rights that you'll be giving up if you complete these plea agreements today. If at any point during this process you don't understand my questions or you need some more time to talk to Mr. McLaughlin, just let me know and I'll give you all the time that you need within reason. Do you understand everything so far?
Yes, sir.
Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
Put your hand down. Mr. White, do you understand you are pleading guilty in both of these two cases?
Yes, sir.
And do you understand the sentence recommendation of 3 years to serve on probation on 012 and 7 years consecutive and 043? Do you understand all that?
Yes, sir.
And is that what you agreed to plead guilty to before you came out here to the podium?
Yes, sir.
Before the court can decide or determine whether or not to accept these pleas and these recommendations, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all of your rights, that you know and understand what you're doing, and that you're doing it of your own free will. So it's vitally important that you speak up if something happens that you don't understand. In 012, that is possession of methamphetamine. That is a felony. It has a maximum sentence of 3 years to serve with a range of 1 to 3. And in 043, aggravated stalking, also a felony, 1 to 20, with 20 being the maximum, with a range of 1 to 20. The court does further advise you that you cannot be forced or compelled to enter a guilty plea today. You can maintain your not guilty plea on all of these charges and have a speedy and public jury trial if that's what you wanted, where you would enjoy a presumption of innocence that would remain with you throughout the trial, and the state would have the burden of proving your guilt to the satisfaction of a jury beyond a reasonable doubt. You would have the right to have your lawyer represent you at all stages of the trial, and if you could not afford to hire a lawyer, then the court would appoint a lawyer to represent you. In the trial, you would have the right to confront, question, and cross-examine all witnesses and persons who accuse you. You would have the right to defend yourself and to bring into court your own witnesses and evidence in your behalf. And at your request, the court would issue subpoenas directed to your witnesses to compel them to come to court. You would have the right to testify in your own behalf, but you could not be compelled to testify nor to incriminate yourself, because you have the right to be present and remain silent. You would also have the right to ask the court to suppress any illegally obtained evidence. And if the jury should find you guilty, you would have the right to appeal that guilty finding to a higher court. And that would include the right to be represented on that appeal by either your court-appointed attorney or private retained attorney, as the case might be. Mr. White, do you understand that if you complete these plea agreements in these 2 cases, you will be waiving or giving up all of these rights that I've just explained to you? Do you understand that?
Yes, sir.
Fourth Amendment waiver will be a condition of your probation. Do you agree and understand that as a special condition of probation will be that you shall submit to a search of your person and property at any time of the day or night, with or without your consent or a search warrant, whenever requested to do so by a probation officer or a law enforcement officer? And if anything is taken, it may be used against you as evidence in a further court proceeding. Do you understand that?
Yes, sir.
Now, you're represented here today by Mr. McLaughlin. Is that correct?
Yes, sir.
Have you had enough time to talk to him about both of these 2 cases?
Yes, sir.
Do you need any more time to talk to Mr. McLaughlin about either of these 2 cases?
No, sir.
Do you have any objections about how your lawyer has handled these 2 cases?
No, sir.
Is this your free and voluntary plea?
Yes, sir.
Has anyone threatened you or frightened you to force you to plead guilty?
No, sir.
Other than the plea recommendation, has anyone promised you anything to get you to plead guilty?
No, sir.
Are you under the influence today of any intoxicants like alcohol, drugs, narcotics, or prescription medications?
No, sir.
Is your mind clear today?
Yes, sir.
Do you know where you are and what you are doing?
Yes, sir.
Can you read and write?
Somewhat, yes, sir.
Well, have you had all of this sufficiently explained to you?
Yes, sir.
Do you have any questions about anything that's happened up to this point?
No, sir.
Do you need any more time to go over this or need me to explain anything else?
No, sir.
If you are not a United States citizen, a guilty plea will affect your immigration status. Mr. White, in case number 25 CR 012, are you pleading guilty to possession of methamphetamine because you are in fact guilty?
Yes, sir.
In 043, are you pleading guilty to count 1 aggravated stalking because you are in fact guilty?
Yes, sir.
All right, Mr. McLaughlin, see that his pleas get entered.
It was terrifying walking into Judge Fleischer's courtroom that first time. I thought I was going to get arrested. I was texting Victoria, "Are you sure? Are you sure I can come in? Victoria, please, are you sure this isn't safe for me?" Well, it's just getting worse, CJ. Just kids that go through school can't comprehend, and I think it's because we need to teach them this way. I think we have to change the way we teach children, and it has to start being this is what they use every day. This is their life, good, bad, or whatever. That's not going to change. Them using their iPhones and their iPads are not going to change. I think we have to shift big time into the way they get taught. Sitting 30 children in one room and having one teacher when they all learn at different levels, I don't know though. And he muted it again. So don't tell me about, go ahead, tell me the audio. It's muted. It's muted. I can't hear. There's no sound. Oh my God, there's no sound.
Count one in both cases has been entered.
Facts of the cases, please.
On or about the date of the indictment, in 25 CR 012, deputies with Wheeler County Sheriff's Office made contact with Mr. White in reference to a call they had received. Upon making contact with him, they were able to locate a small amount of methamphetamine on him.
You earned this one. You earned it.
The victim in that case had obtained a TPO against Mr. White, and shortly after the TPO was obtained, he did try to contact her through Snapchat.
Mr. McLaughlin, anything from the defendant?
Your Honor, we'll stipulate as a factual basis.
Thank
both
you,
of these
Kelly.
pleas.
Thank you, thank
Mr.
you.
White, obviously I'm not going to pretend like we don't know each other. We're related. We're fairly close kin. Mr. White, I think, like many other folks who've come before the court today, have had the same issue, and that is trouble with methamphetamine.
Oh, that's his trouble? Meth? I did call their courtroom, Monica. I did. I called and I'm like, hey, why isn't Judge Reeves playing anymore? Where is he streaming? Well, that's up to him whether he streams or not. Well, no, we miss him. We miss him. He needs to start streaming. He didn't start streaming again. He didn't. Even though I called and told them he needs to start streaming again, he did not start streaming. So now we get Mikey and talking about meth. When imagine how Judge Reeves would have handled this.
He also is, I will say this for him, whenever he does something, he usually admits it. And if I recall correctly, when Mr. Giles went to arrest him, he said, is this about that girl that I texted I wasn't supposed to? And that pretty much does it. So that's why this is a guilty plea. We just ask the court to accept the recommendation. And I'm hoping Drew's now, he tells me he's about to be 32. Starting to put all this behind him. If not, he knows what awaits. I would ask, just to put on the record to notify probation, he's probably, I know my Uncle Pete's not letting him use the truck anymore, so he's probably gonna have a hard time as far as work goes. So I would ask if he can do some community services fine conversion in the meantime until he gets his ride situation sorted out. I told him that they will usually work with folks that can't pay. So I'd ask the court to approve that if it deems fit.
No. Hold on. Now, I don't buy meth, but I suspect it's not cheap. I suspect you can't just give him $1. Here's $1. Give me some meth. So if he can afford meth, how is it that he cannot afford this court? I can say it. It's fine. It's in a court context. But we can't say it in chat. But I can say it. It's good to be king.
Any questions about anything that's happened up to this point?
No, sir.
Is there anything that you would like to say? You don't have to, but you can if you want to.
No, sir.
Very well. The court finds that the pleas have been freely and voluntarily entered, that there is a factual basis for the pleas, and the court will accept the recommendations as were stated on 012, 3 years on probation with $500 fine subject to a suspended RSAT, which will be in both cases. And I'll come back to those in just a second. $500 if I didn't say it already, plus the add-ons that go with it. Count 2 will be null prost. In 25 CR 043, count 1, that will be 7 years on probation consecutive to 012, $500 fine plus the add-ons that go with it. And that probation will also be subject to the following conditions. In both cases, the suspended RSAT, and what that means is, Mr. White, is the RSAT sentence of the court will be suspended upon no violations of probation, no new criminal charges, and most assuredly and most specifically no new felony charges. Any of those would be deal breakers, and you'd be brought back for execution of the RSAT sentence. You understand
It's like community corrections. So it's not prison, but you're not released into the public either.
that, Mr. White?
Yes, sir.
And in 043, no contact with the named victim in any way, shape, form, or fashion, directly or indirectly, or through any electronic communication device or platform. Be served under drug and alcohol conditions, Fourth Amendment waiver conditions. You have a period of 4 years to file a habeas corpus petition from the date these sentences become final, 30 days to file a notice of appeal or a motion for new trial. Do you possess a concealed carry permit for a firearm, Mr. White?
No, sir.
All right, you'll need to see Chief Carmen here. He'll process you through. Good luck to you, sir.
We're doing this from here, so I can have my notes, okay?
Stand up or sit down.
Just stand up until, we'll sit down once he gets through this initial stuff.
I'm just make sure I'm doing the right thing. Now, my calendar says sentencing hearing, but he hasn't pled.
He has not pled. We
Okay.
have the plea sheet that has been signed. We made the announcement that this would be a capped offer. We subsequently got the paperwork signed. The state intends to make a recommendation. We plan on arguing for
Well,
something
I
different.
understand that. I just wanted to make sure. I've got to go through the full plea colloquy.
Gotta go
Okay.
through the colloquy, yes, sir.
All right. Very good. Well, let's do that at the podium, and then you can move
Okay.
on. Okay.
Come here. Be careful. Don't put that in my bag.
All right, give me just a second here. It's a negotiated plea, Ms. Cameron?
Yes, Your Honor.
All right, let's get it on the record. This is case number 22CR053-J, State versus Christian Collins. That's you, sir?
Yes, sir.
I'll note for the record that Ms. Collins is standing at the podium with his attorney, Ms. Cameron. I have a plea sheet here in front of me that Ms. Cameron has handed up. So Ms. Cameron, run through that for me real quick.
Your Honor, the plea sheet, we anticipate the state to make a recommendation 2215. We will be arguing for different. That will be a cap on the 2215. We will be requesting, to the court is aware of what we would be requesting. We will be requesting 20 years probation with 1,321 days to serve, credit for time served. He has been locked up since December of 2021. A $1,500 fine, drug and alcohol conditions, Fourth Amendment waiver. No unsupervised, no contact with minors, and any contact with minors that are his relatives would be supervised contact. And that he would obtain his GED as part of his probation, and any other conditions that the court would impose on that probated sentence is what we would be requesting, Your Honor.
And what is the state? I know the agreement is capped at 15 to serve. Is that what you're going to say?
Yes, so the state's recommendation is going to be 20 years with 15 to serve at the Department of Corrections, no contact with minor children, and then no contact with the victim in the case.
Okay, so that's going to be your recommendation is 20 to 15 balance on probation.
Yes.
Okay.
And the difference between the contact was they're asking for.
Oh, okay. Say that again.
So I'm going to ask for no contact with minors or with the victim in the case.
Okay.
And then standard conditions and $1,000 fine.
All right, Ms. Collins, I know this is a complicated case, but it appears that you, excuse me, and Ms. Cameron and the DA's office have reached the partial agreement. As I understand the situation, or the recommendation to the court, is you are expected this afternoon or this morning to plead guilty to count 4, and then the court will be presented with 2 choices or recommendations. Do you understand that the state is going to recommend that you do 15 years to serve in prison with a 5 years or balance of the 20 to be on probation with those conditions? So you understand that's what the state is going to recommend?
Yes, sir.
And as I understand the recommendation, or what you and Ms. Cameron are going to do, is ask the court to sentence you to straight probation, 20 probation.
With credit for the time served,
Correct.
obviously.
Give you credit for the, what is that, 3 years almost of?
3 years, 7 months, and a few days.
So give you credit for all the time that you've done towards your sentence, but that the balance of that be served on probation with a fine, and the court will have to hash through all these other conditions. But Mr. Collins, do you understand the 2 recommendations?
2 recommendations.
Do you understand the 2 recommendations, that the state's making a recommendation and I'm making a recommendation?
Yes, sir.
All right, you do understand that. All right, very good, Mr. Collins. Well, before I can even get to that point, I have to first go through a process with you where I ask you a series of questions to make sure that you understand all the details of this, but just as important, that you understand all the rights that you'll be giving up if you complete this guilty plea. If at any point during this process you don't understand my questions, or you need some more time to talk to Ms. Cameron, just let me know, and I'll give you all the time that you need within reason. Do you understand everything so far, Mr. Collins?
Yes, sir.
All right, as best you're able, please raise your right hand. Do the best you can. Do you swear or affirm under penalty of perjury that the testimony you give here today shall be the truth?
Yes, sir.
You put your hand down. Mr. Collins, do you understand that you're expected this morning to plead guilty to count 4, which is child molestation? Do you understand that?
Yes, sir.
Your Honor, just for clarification purposes, and I think I failed to mention this, this would be an offer to plead to count 4.
Oh, okay. I'll make a note of that.
That is indicated on the police sheet. Or it should have
Okay.
been.
All right, I'll come to that in just a second as well. But do you understand, Mr. Collins, that this plea agreement will require that you plead guilty to child
Yes, sir.
and child molestation is a maximum sentence of up to 20 years to serve in prison with a range of 1 to 20 to serve in prison. The court does inform you that before the court can decide or determine what to do with this case or how to dispose of this case, or even to accept your guilty plea, the court must first determine that you are making a knowing, intelligent, and voluntary waiver of all.
I didn't know. I didn't know. I did warn you guys that I get like 9 of these per docket. I want to know if he gets prison or if he gets probation. She doesn't. Is that a she? I'm guessing it's a she. She doesn't look like it's that. She looks like it's something else. Oh, it must be something worse because he muted the whole thing. Oh,
Is that the only tampering?
last one. Come on, Mikey, unmute.
Do
Thank
you
you.
have any concerns with him being around Cameron?
No.
If he comes home. Okay. And you have another baby on the way. And is that the only two children you'll have is Cameron and the child that's on the way? Is that a yes? Okay. And do you have any concerns with him being around Cameron or that child?
No.
And why do you?
Oh,
have
it's
any
the same
concerns
guy.
with him being-
Same guy, same guy, same guy. Look, he's sitting right there. He might be the last one on this docket. We might be done. We're done. All right, guys. Thank you so much for coming out. I appreciate it. I really do. I hope you guys have a great, great, great day. You'll be flipped over to OJ. So if you don't touch anything, you're automatically going to watch the OJ Simpson trial. Bye, guys. Behave.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no